Welcome back to the Constitutional Clarion. This video is the third in a series about the New South Wales Lang Government and the constitutional crises that it faced, or indeed provoked. In this video, I'll look at the battle that ensued between the Commonwealth and the states over money, which resulted in the state withdrawing all its money from the banks and in fact running on a cash basis, and on the other hand, the Governor-General confiding to the King that he contemplated refusing royal assent to a Commonwealth bill. But first, a little background. In 1929, as the Great Depression began to bite, something rather unusual happened in Australia. A Commonwealth referendum was actually passed. It inserted Section 105, capital A, in the Commonwealth Constitution, which allowed the Commonwealth to make agreements with the states concerning taking over state debts and the indemnification of the Commonwealth by the states in relation to the debts that were taken over. It allowed the Commonwealth Parliament to make laws to give effect to prior and future financial agreements. Astonishingly, it said that those agreements were binding on the Commonwealth and the states, notwithstanding anything in the Commonwealth or state constitutions or any Commonwealth or state law. A financial agreement between the Commonwealth and New South Wales had been entered into on the 12th of December 1927, prior to the adoption of Section 105A of the Constitution. After Section 105A was approved in a referendum and came into force, the Commonwealth and New South Wales Parliaments then legislated to validate the earlier financial agreement. However, the Lang Government, which was elected in 1930, did not support that agreement. As the Depression began to take its toll on Australian economies, various plans were proposed to implement a recovery. The Melbourne Plan of August 1930, based upon the advice of Sir Otto Niemeyer, proposed harsh economic measures to reduce government expenditure, balance state budgets, and give priority to paying overseas debt. In contrast, the Lang Plan included the suspension of the payment of interest on overseas debt in order to give priority to the payment of pensions and other social services within Australia. In accordance with the Lang Plan, New South Wales defaulted in its obligations to pay interest to overseas bondholders in April 1931. The Commonwealth Government took over the payment of the state's interest obligations, but New South Wales did not pay to the Commonwealth the proportion of interest debt required under the financial agreement. The Scullin Labor government at the federal level, while disputing with Lang his methods for dealing with the financial crisis, ultimately supported him through additional loans. It was Lang's supporters in the Commonwealth Parliament who actually brought down the Scullin Labor government in a vote of no confidence. A federal election was held in December 1931, bringing the Conservative Lyons government into office. Lyons was bitterly opposed to Lang's policies and determined to fight tooth and nail to obtain repayment by New South Wales of amounts spent by the Commonwealth in taking over the payment of interest owed by the state to overseas bondholders. The first phase of the financial struggle between the Commonwealth and New South Wales governments was litigious. On the 3rd of February 1932, the Commonwealth Government issued a writ against the state for just over £950,000. The Commonwealth then enacted two statutes pursuant to Section 105, capital A of the Commonwealth Constitution. These formed part of what Lang later described as a regular orgy of bitter, punitive legislation against this state by the Commonwealth Parliament. They provided that the Commonwealth was entitled to recover from the state the money it was owed under the financial agreement, and it set out a procedure for getting this money. This included being able to require a bank which holds state funds to pay that money to the Commonwealth Treasurer, making it an offence for the bank to refuse to do so. This bill was given assent on the 21st of March 1932. The Lang Government challenged the validity of these acts in the High Court. The case was heard in March 1932 and the High Court announced its judgment on the 6th of April 1932, handing down its reasons later on the 21st of April. The majority of the High Court upheld the validity of the Commonwealth legislation. The majority was comprised of Justices Rich, Stark, Dixon and McTiernan, the latter having been Lang's young Attorney General, who had earlier been sent to London to petition the King and who had indeed saved Lang's leadership by a telegraphed vote from his ship at sea on his return to Australia. On that, see my previous video. On the 18th of April, New South Wales argued in the High Court that a certificate should be given allowing it to appeal the High Court's decision to the Privy Council. This was denied by the High Court on the 22nd of April. On 18 April, New South Wales also argued in the High Court that an order by the Commonwealth Treasurer to the banks to pay to the Commonwealth funds standing to the credit of the state was invalid, as were claims upon money in certain state funds, such as the estates administered by what was then called the Master in Lunacy, who held money for mentally incompetent persons. This challenge failed by the same majority on the 22nd of April 1932, with written judgments handed down on the 3rd of May. By that date, Lang had exhausted all legal avenues to overturn the Commonwealth's action. The battleground moved from the courts to a tactical game of cat and mouse with the state's revenue as a prize. In response to these court decisions, Lang was defiant. He argued in Parliament that the executive of the state has the right and the duty of securing self-preservation to the state, and it is going to perform it. He was prepared to defy the courts, arguing that constitutional law is made up of action and events, as well as written statutes and judicial decisions. He concluded that, quote, "This government says today that not all the high courts in Australia can compel the government of New South Wales to rob its own people to pay foreign bondholders," unquote. Earlier, the Lang government had withdrawn the state's funds from trading banks in very large suitcases in small denominations, which were heaped on the back of trucks which had men with rifles protecting it. And it deposited all of this money into the New South Wales Treasury, which actually literally did become a treasury. For those of you who are old enough to remember the old Disney cartoons, it was actually rather like Scrooge McDuck's money bin, with money just stacked everywhere. The Prime Minister, Joseph Lyons, told the press that, quote, "Mr. Lang is deluding himself if he thinks that his action is a means of evading the effective weapon which has been forged by the Commonwealth Government to compel him to meet his undertakings," unquote. The New South Wales Government then operated, again, literally on the basis of a cash economy without actually going through the banks because it couldn't even use cheques. It doled out cash from the Treasury building as necessary while waiting for the resolution of its court challenges. On 7 April 1932, the Sydney Morning Herald reported the major news stories of the day. What were they? Well, in order of priority, first, the great racehorse, Phar Lap, had died. Second, Francis de Groot had been fined £5 for cutting the ribbon at the opening of the Sydney Harbour Bridge. And third, the High Court had upheld the validity of the Commonwealth's enforcement legislation. So enforcement then began in earnest. The Commonwealth fired the first salvo. It issued proclamations under the Financial Agreements Enforcement Act on the 7th of April, requiring state income tax to be paid to the Commonwealth rather than the state. Lang responded by attempting to block the Commonwealth. The locks were changed at the tax office, that's the state tax office, so that Commonwealth officers could not gain access to taxpayer records. State taxation officers were sent on leave or transferred to work on the few taxes that were not claimed by the Commonwealth. The Sydney Morning Herald described this as a, quote, dramatic countermove, unquote, and published a rather stark photograph of one of the locked doors. The Commonwealth hit back on Monday the 11th of April with regulations and proclamations designed at compelling the production of state tax records and instructing trading banks to surrender to the Commonwealth state funds that were in their possession. Lang had already largely thwarted that tactic by removing most of the state's money from the banks, although some remained, such as special funds dedicated to particular purposes, including the funds of the public trustee and superannuation funds. These were seized by the Commonwealth. Its campaign, however, netted very little of the state's ultimate debt. Kane records that until the 28th of April, the banks had surrendered to the Commonwealth no more than £7,311, at a time when New South Wales' debt to the Commonwealth had by then blown out to £2.7 million. The payments increased after that, with £57,927 being transferred to the Commonwealth by the banks on the 29th of April and another £49,025 being transferred on the 10th of May. But it was still not a significant amount of the state's debt. By April 1932, the calls for the governor to dismiss the premier had become very loud indeed. They were epitomised by this editorial in the Sydney Morning Herald on the 12th of April 1932, which said as follows, quote, "No government can carry on which is deprived of the power to pay and receive monies by cheques or through the banks, and with its creditors generally hostile to its administration. There is only one thing left for the Lang government to do, and that is to resign and go to an election. If Mr. Lang should not now take this course within a reasonably short time, and yesterday's developments very much shortened the permissible period, then it's difficult to see how the state governor can refrain from demanding his resignation. Mr. Lang chose to appeal to the highest Australian court, and the court decided against him. He has now refused to recognise that decision. The responsibility upon the state governor to do his part under the Constitution to prevent the worst collapse is ultimately inescapable, and we believe that the hour for action by the state governor, if Mr. Lang be determined that the end shall come that way, is close at hand. The present situation cannot continue." Unquote. Lang's last roll of the dice was an attempt to raise the necessary funds to satisfy the Commonwealth's demands by taxing the property-owning class through the enactment of the Mortgages Taxation Bill 1932. It would have imposed a tax of 10% on the total secured amount of a mortgage. If this amount were not paid within 14 days, the mortgage was then to vest with the Crown, freed from all charges and interests. Lang estimated that this bill would raise £7 million, which would have enabled the state to satisfy the demands of the Commonwealth Government and thus, quote, remove the crippling embargo inflicted by the federal government authorities upon the wealthiest and most populous state of Australia, unquote. Lang argued in Parliament on the 11th of May 1932 that the Commonwealth had, quote, invaded the state of New South Wales, taken over its revenues and allowed its services to perish. He went on to say, "Only one of two courses can be taken with an invader. He must either be paid out or thrown out," unquote. He concluded by stating that he asked the Parliament, quote, to pass this bill so that we may first of all try the method of paying them out, unquote. The unstated implication was that if the Commonwealth could not be paid out, it must be thrown out by force. It's not clear whether Lang actually intended for this bill to pass. Newspapers speculated that he was deliberately introducing drastic financial bills that were likely to be rejected by the Legislative Council, but which could serve as window dressing tactics leading up to a general election. If the mortgages taxation bill were defeated in the Legislative Council, Lang could have then gone to an election arguing that he had all the financial answers but was being thwarted by the Legislative Council and also the Commonwealth Government. This might have been his best chance to save his position. Instead, the Legislative Council called his bluff by passing the bill early on the morning of the 13th of May 1932. Later that same day, the Commonwealth Parliament then passed the Financial Emergency State Legislation Act 1932, which was intended to counteract the imposition of this mortgages tax by the state and prohibit any fine being imposed for the refusal to pay such a purported tax. Whether the Commonwealth legislation would have been effective, however, remains doubtful. The Governor-General at the time was Sir Isaac Isaacs, the former Chief Justice of the High Court. In one of his many long missives to the King, which I tracked down and read in the Royal Archives at Windsor Castle, Isaacs explained that he did not think that the Commonwealth had a head of legislative power to pass this law. While the Commonwealth had the power to make laws with respect to taxation, this was confined to Commonwealth taxation and did not extend to laws about state taxes. Other powers relied on, such as the corporation's power and powers with respect to banking and insurance, had all been interpreted very narrowly by the High Court during that period and probably wouldn't have supported the law. While Isaacs considered that he did have a reserved power to refuse royal assent to bills in the case of what he called plain illegality, because even the Governor-General must obey the law, according to the principle of the rule of law, he thought that the validity of this particular bill was at least contestable. In recognising the possibility of such an emergency power, Isaacs was in effect suggesting some kind of nationhood power many decades before it was actually recognised by the High Court. Isaacs concluded his explanation to the King by saying, quote, whether it is valid or not, or how far it is valid, will not be known until the High Court pronounces upon it, should the occasion arise, unquote. But the occasion did not arise because that very afternoon, the Lang government was dismissed by the Governor, Sir Philip Game. The incoming Stevens government sought not to proceed with royal assent to the mortgages taxation bill, so it sat abandoned in the Governor's desk drawer. Later, a law was passed in 1935 to annul the bill, lest a Labor government be re-elected and advise the Governor to give assent to it. Thank you again for watching the Constitutional Clarion, and I look forward to seeing you next time for the grand finale, which is about the dismissal of the Lang government. Goodbye.